On April 5, 2018, a grand jury in Hillsborough County, Florida, indicted Ronnie O'Neal III on 7 criminal charges arising from a violent incident that occurred late on the night of March 18th, including 2 counts of first-degree murder, attempted first-degree murder, first-degree arson of a dwelling, 2 counts of aggravated child abuse, and resisting an officer without violence. Mr. O'Neal was accused of killing his 9-year-old daughter, Ronivia O'Neal, and the mother of his 2 children, Kenyatta Barron, attempting to kill his 8-year-old son, Ronnie O'Neal IV, and setting the family home on fire. According to the criminal report affidavit, Hillsborough County deputies were dispatched after receiving multiple 911 calls, including one from a woman pleading for help and stating that she had been shot, and another from Mr. O'Neal himself, who claimed he had been attacked and admitted to killing the victim. When deputies arrived at the residence, they discovered Ms. Barron's body in the front yard of a neighboring house with fatal gunshot injuries and stab wounds, and observed an active fire inside the home. First responders also encountered Ronnie IV, who had suffered severe stab wounds and burns, but survived after emergency surgery, and later found Ronivia deceased from multiple stab wounds. On May 21, 2018, the state of Florida filed a formal notice of intent to seek the death penalty, and in October of 2018, the court determined that Mr. O'Neal was not competent to stand trial and committed him for competency restoration treatment. In June of 2019, the court issued an order finding that Mr. O'Neal had been restored to competency and the case could proceed. The case was decided by a jury trial in June of 2021, and Mr. O'Neal chose to represent himself. In this episode, we will review his opening statement, which is the brief presentation at the start of a trial during which each side tells the jury their version of what they expect the evidence to prove.
The evidence is going to show that we are under some of the most vicious, lying, fabricating, fictitious government you ever seen. By the time it's all said and done, you will see who is the mass murderers in Tampa Bay, the state of Florida. You will know why what occurred on March 18, 2018 occurred. And the evidence is going to show that law enforcement tampered with evidence to meet their such high burden of proof. Because originally, it wasn't enough. So we had to tamper with evidence. Since it was such evident already, but we still had to tamper with evidence. The evidence is going to show my son did not see me murder his mom. The evidence is going to show he did not see me shoot his mom. The evidence is going to show my son said many things that are not true. The evidence is going to show that I called 911 during Kenyatta Barron's 911 call. But all of a sudden, it ends up after I called Kenyatta, after Kenyatta Barron's call was made. Now I'm calling 911. But originally, I called 911 without even knowing she called 911 during her call. But the evidence is going to show that your representatives and law enforcement, local law enforcement, wanted to make it seem like I'm some kind of menace to society. And I ran after killing Kenyatta Barron, knowing that authority was on the way to kill my own children. I wonder why I would do something like that for no reason. The evidence is going to show my son did not witness me viciously beat his mom to death. The evidence is going to show my neighbor, Khalil Brown, whom they are trying to keep out of this trial, witnessed me take 3 strikes. The evidence is going to show that law enforcement and this administration wanted to make me look like a menace to society. So they added several mini strikes on that video and audio that you just heard.
During his opening statement, Mr. O'Neal asserts that the evidence presented at trial would show that he only hit Ms. Barron 3 times, and that law enforcement officers tampered with evidence to make it look like he hit her more times than he did. However, the medical examiner, Dr. Mainland, who visited the crime scene and later performed Ms. Barron's autopsy, testified that her right arm was broken in 2 places, that she suffered a gunshot wound to her right back shoulder and another larger gunshot wound to her right elbow, and that she suffered numerous injuries to her head, including over 15 separate lacerations, multiple abrasions and contusions, 6 or 7 fractures to the skull, including a fractured jaw, fractured facial bones, and several fractures at the base of her skull. Several of her teeth were missing, and Dr. Mainland testified that Ms. Barron died from blunt force trauma, leading the court to conclude that there was clear and convincing evidence that Mr. O'Neal had beaten Ms. Barron to death, presumably by a shotgun that an investigator found broken into pieces.
And they added several statements that I did not say. Anything that I may have said, they exacerbated it and made me say it consecutively over and over like Allahu Akbar, which I may have said once or twice. But they wanted to make me seem like a terrorist, and so you hear it 8 or 9 times, and you hear me calling Kenyatta Barron a and a. The evidence is going to show that I called my dad after calling 911. But that call is all of a sudden missing from the T-Mobile records that we have acquired from T-Mobile. The 911 call that I made to 911 and the 911 call that you just heard cannot be proven that it was made, because after I called for an investigation of those 911 calls, all of a sudden they become missing from all evidence. The evidence is going to show Kenyatta Barron supposedly made a 911 call, but you cannot find that on her call log, which we pulled from her actual phone. They say she made a call at 11:43. There's no 911 call at 11:43 on her call log. All of a sudden, after I called for an investigation of the original calls, that's what the evidence is going to show. The evidence is going to show I look alone, but I am backed by a mighty God. The evidence is going to show I love my children. And the evidence is going to prove to you that this whole entire case has been tampered with and fabricated before it's all said and done. I can guarantee you that. Mark my words. The evidence is going to show that they say, I said, come out here, son, and help me kill this bitch. But my neighbor, Khalil Brown, nor my neighbor, Mona Lisa Brothers Gray, or any of her children, Mia Thompson, or Gracie Diggs, or Mr. Gray, heard me say any of those things. In fact, the evidence is going to show that Khalil Brown heard me say she killed me twice and then nothing else. The CRA is going to show. For some of you who don't know what that is, that's the criminal report affidavit that the law enforcement lead detective Thomas Dirks is the author of. The evidence will show that in that CRA, I told the neighbor, don't come outside, call 911 now. But you don't hear that on this audio for some reason. But you hear all these other things that I did not say. That same CRA will have the statements of Khalil Brown saying that he saw me take 3 strikes with that shotgun and nothing else. The evidence is going to show that Mr. Harmon here says that big chunk missing out of her arm was a bird shot. It was not a bird shot. And whatever kind of shot it was, if it was a slug shot or a bird shot, where's the missing pieces of her arm? The evidence is going to show you will not see any missing pieces of her arm in that closet where she was shot. You should see some evidence of shots, but there were several shots added to the wall to make it look like I aimed at her head. That's what the evidence is going to show. You remember I told you the evidence will not show you that my son witnessed me beat his mom to death, nor did he witness me shoot his mom. In fact, he didn't witness much at all.
Mr. O'Neill also argues that the evidence would show that Ronnie IV did not actually see him beat or shoot Ms. Barron. However, when Ronnie testified at trial, he stated that he saw his parents arguing, with Mr. O'Neill holding a shotgun and Ms. Barron screaming at him. He then saw Ms. Barron run into a closet, and Mr. O'Neill followed her with the shotgun, telling Ronnie to walk around and say, Allah Akbar. Ronnie then testified that he heard a gunshot and saw Ms. Barron stumble out past him to go outside. Mr. O'Neill then chased her with the shotgun while Ronnie stayed inside. About a minute later, Ronnie saw Mr. O'Neill come back inside, grab Ronivia by one arm, drag her into the master bedroom, and hit her in the head with an axe. Ronnie then witnessed Mr. O'Neill spreading gasoline all over the house and dropping a match on the ground. Ronnie also testified that Mr. O'Neill stabbed him with a knife and tried to set him on fire. Law enforcement officers testified that upon arriving at the scene, the house was on fire, and that Ronnie had suffered knife wounds to his chest, neck, face, arm, and leg. There was an open evisceration of his abdomen, and there were burns to over a quarter of his body. Officers also testified that when Mr. O'Neill came out of the garage, he smelled like gasoline and had blood on his clothes and hands. Additionally, forensics investigators found holes in the closet doors that were consistent with shotgun projectiles, waddings and pellets on the closet floor, 3 spent casings and live rounds, a shotgun slug from the closet wall with red fabric, and Ms. Barron's blood on the closet door. Investigators also recovered a knife handle and knife blade containing Ms. Barron's blood in the garage, and a knife handle and hatchet handle with Ronivia's blood.
And the evidence will show that my son said my dad shot my mom. Is the correct statement if you want to cite statements, if he even said it. Because I can guarantee you, the evidence is going to show you we are under the most corrupt administration you've ever seen in your life. I guarantee you I wouldn't waste your time. I would have already took a plea deal of some kind if I knew I did something like this, because most people don't even go to trial when they know they've killed somebody unjustly. The evidence is going to show you who the killers are. I'm pleading not guilty to the charges of premeditated murder, attempted murder, aggravated child abuse or battery, arson, resisting arrest without violence. And while I'm at that, the evidence is going to show that they tased me for no reason. But they tampered with that video because they didn't want you to know the truth. And it might sound far-fetched, but I guarantee you we're going to see who the liars are before it's all said and done. Mark my words. Because my family lives were taken when my daughter was done. This is what the evidence will show. When my daughter was born, it was me who gave the command, the final command to keep her alive when she was on life support. When she was born 2 pounds, 2 ounces, and couldn't breathe on her own, it was me who fought to keep her alive. But all of a sudden, I just want to take her life for no reason. I'm asserting justifiable homicide because I acted in self-defense and moved to protect myself and my children from Kenyatta Barron.
Mr. O'Neill asserts the defense of so-called justifiable homicide, arguing that he acted to protect himself and his children from Ms. Barron. Under Florida law, justifiable homicide is a narrow defense that applies only when a killing is legally excused because it occurred under specific circumstances defined by statute, most commonly lawful self-defense or defense of others. Section 776.012 and Section 776.013 of the Florida statutes permit the use of deadly force only if a person reasonably believes such force is necessary to prevent imminent death, great bodily harm, or the imminent commission of a forcible felony against themselves or another. However, under Section 776.041 of the Florida statutes, this defense is not available to a defendant who initially provoked the use of force against them, except in rare and narrow circumstances. In other words, even if there was any element of truth to Mr. O'Neill's claim that Ms. Barron attacked him, it is highly unlikely that he would succeed in a justifiable homicide defense if the jury concluded that he was the initial aggressor.
I'm going to be showing with evidence several reasonable reasons to doubt the state's allegations against me. The evidence will show that the state cannot prove that I premeditatedly killed anyone because I didn't have any time to reflect or plot and plan as if everything happened suddenly and spontaneous. I responded out of pure instinct and heat of passion, eliminating any kind of premeditated design. And let me just say, the evidence will show that since the state plans to kill me, if they can say that I killed my family unjustly, they plan to premeditatedly kill me, so they cannot say or deny me the right to premeditatedly kill Kenyatta Barron if she killed my children. The evidence will show that Kenyatta Barron had several medications and drugs such as morphine in her system. The evidence will show she had a domestic history and was arrested for domestic violence that same year. She also was born premature, just like Trinivia.
Judge, I object at this point.
I'm going to sustain the objection as to that particular argument regarding Ms. Barron being born prematurely. All right? You may continue on, Mr. O'Neill.
I didn't even state the basis of his objection.
I've ruled, Mr. O'Neill, okay?
I understand, but I have to state the basis of my objections, right?
Well, that is correct, and I just assume what the objection is. So go ahead and state it for the record, Mr. Harmon.
Proper argument.
That's sustained.
The evidence will show that she threatened to kill me with a knife just a few weeks before the incident, and she was angry about my relationship with my other child's mom, and about the fact that we had to be cordial for our newborn son. And the evidence will show that they had been going back and forth and arguing on Facebook and by telephone that whole afternoon before the incident. The evidence will show that me and my son was at my mom's house while I was putting brakes on my aunt's car. Me and my son spent the whole day at my mom and dad's house working on the car. When we came back home, I never knew she was arguing with my child's mom, my other child's mom, the whole day. That's what the evidence will show. Evidence will show that my daughter was prematurely born. She was autistic. My son Ronnie was diagnosed at the age of 3 with developmental delay and had the history of SLD. The evidence will also show that he was present but does not remember accurately or consistently what happened for many reasons, making him unreliable when it comes to the actual facts. He also has been diagnosed with PTSD, as he should be, because this is a very traumatic thing that he went through. He also was diagnosed with major depression disorder, intermittent confusion, and delirium. The evidence is going to show, the evidence and testimony will show that Ronnie Blair, formerly known as Ronnie O'Neal IV, may have been coached on what to say by family members.
Objection to argument.
And or law
Hold on. I will overrule the objection.
Thank you, Your Honor.
Mr. O'Neal, again, jury, this is what both sides believe the evidence is going to show. All right? And again, you will be the ultimate determiner of what the facts are. You may proceed, Mr. O'Neal.
Thank you, Your Honor. And these are also actual facts that Mr. Harmon left out when he told you about the report of his former psychologist, when he told you that he was adopted by his family members, which didn't work out as well, and he had to be placed with another family, which is now the Blair family. In that same report, it talked about how he may have been coached by family members. The evidence is going to show that my son was adopted by a detective who formerly worked in this case, whom he now lives with. And I don't have a problem with that because he needs care. But I do have a problem with Mr. Blair being involved in this case, being called as a witness, being the new father of my son, and now he's being called as a witness when he could possibly have been coached by his new father,
Objection.
who is
Speculation
law
and proper
enforcement.
argument.
All right, and again, Mr. O'Neal, overrule the objection. Again, this is what Mr. O'Neal is asserting the facts will be. You may proceed.
Thank you, Your Honor. The evidence will show and prove that very vital evidence was definitely tampered with, which was a strategic omission to cover up the facts of this case, making much more of the evidence unreliable. As I know for a fact, it was altered as well. The evidence is going to show that the 911 call of Kenyatta Barron is not compatible with what Khalil Brown saw and heard outside of my home. The evidence is going to show, when it's all said and done, who put those excessive lacerations on Kenyatta Barron's face. I can guarantee you that. In this trial or the next one, I can guarantee you that. Because like I said, I look alone, but I'm backed by mighty God. And ultimately, it will show that none of the state's witnesses can draw any conclusions, especially because they didn't see anything that refutes my self-defense claim and theory. And nor can the state do so beyond their very reasonable doubts that will be revealed. The very reasonable doubts that will be revealed by me. And that's all I have to say.
After the opening statements, the trial proceeded for several weeks before the jury found Mr. O'Neal guilty on all charged counts on June 21, 2021. The convictions included the first-degree murder of Ms. Barron and Ranivia, the attempted first-degree murder of Ronnie IV, arson of a dwelling, 2 counts of aggravated child abuse, and resisting an officer without violence, with specific findings that Mr. O'Neal possessed and used weapons during the commission of the offenses. The day after the verdict was announced, Mr. O'Neal decided that he wanted to be represented by counsel in the penalty stage of the proceedings. And on July 23, 2021, Mr. O'Neal was sentenced to life in prison without the possibility of parole, rather than the death penalty. Mr. O'Neal appealed, and on August 18, 2023, the 2nd District Court of Appeal of Florida affirmed his conviction. On April 2, 2025, Mr. O'Neal filed a motion for post-conviction relief. As of the date of writing this episode, this motion is still pending. However, Ronnie IV was adopted by Hillsborough County Sheriff's Office Detective Mike Blair, who responded to the home on the night of the incident. This case illustrates the sharp divide between a defendant's narrative and the evidentiary record ultimately considered by a jury. In his opening statement, Mr. O'Neal framed the events of March 18, 2018 as an act of self-defense and protection, asserting that he was forced to respond to a threat posed by Ms. Barron. However, as the trial unfolded, the testimony of his own son, who survived the brutal attack, the medical examiner's findings, the forensic evidence, and the observations of responding officers painted a far different picture. One of sustained violence, multiple weapons, and actions that continued well beyond any plausible claim of imminent danger. Florida's justifiable homicide statutes impose strict limits on the use of deadly force, particularly where the defendant is alleged to have been the initial aggressor, and the jury was tasked with weighing those legal standards against the evidence presented. In finding Mr. O'Neal guilty on all counts, the jury rejected his self-defense theory and concluded that the state had proven premeditation, intent, and culpability beyond a reasonable doubt. The outcome of this case underscores the role of the jury as fact finder and highlights how opening statements, while important in framing expectations, ultimately